My name is David Gotlinski. I am the property owner at 2100 Northeast 121 Road, North Miami.
And as far as you know, there is no court order preventing me from hearing this case today if your motion to dismiss, your motion for continuance is denied.
I do not believe that there is a court order.
Okay.
I do disagree with the city attorney that the two things we're here for today are related. The license
We're
that
gonna get to that.
okay,
Let's wait on that.
okay.
Um,
Am I understanding the city's attorney's response to your question when she said that there was something preventing you from doing it for things prior to these two cases, but not these two cases? Was that your answer?
Can you clarify that?
I don't understand what part he's referring to.
You said there was something that was keeping me from going forward on the
Right.
case.
No, I said that there's nothing keeping you going forward on the two cases that were set in here for today. What I said was, as it relates to the matters that he wants to discuss that were referenced in his motion for continuance regarding having Mr. Rowland testify to the zoning determination letter and everything that was issued from back in 2016, that is not related to the allegations and the matters that.
They're separate issues.
Correct.
Okay.
They're separate issues.
Okay. So let me hear from the property owner's perspective in terms of why you are seeking a continuance of this hearing.
Your Honor, I think the state case obviously is one of the reasons. I feel that once Mr. Cuzo's letter came in and, the property, was deemed to be, whatever the reason was, why they decided to revoke the license, we appealed to the state. We felt that it was a mistake, that it was an illegal revocation, and that there was no due process.
You appealed it to the state? Why the state?
Because we felt that the decision made by the city was improper.
So you filed a lawsuit.
Yes,
That's not, that's a lawsuit. That's not an appeal to the state. So you filed your attorney filed a lawsuit
correct.
contesting the decision
Correct.
that was made by the city attorney in regards to whether or not you were grandfathered.
That's what I meant to say. If I
Okay.
said it the wrong way, I'm
That's
not
okay.
an attorney.
I think I understand you.
Okay. That would be the first reason. The second reason, I do need time to find another lawyer. Frank Woolen can no longer represent me. He is a key material witness for this case.
How so?
Mr. Woolen had direct communication with the city manager regarding my package, which was all the evidence. It was a file about maybe almost 8 to 10 inches thick, proving that my property should be grandfathered in, that I had met all the requirements of the city ordinances. I purchased the property in 2002. It was legal to rent then, and my property was began the vacation rental in 2008, prior to the change in the law here in the city of North Miami. So I was already providing vacation rentals, and the package that I'm talking about was given to my attorney, who's not my attorney now, Frank Walland, who attempted to get the city manager to review it. The city manager didn't even want to look at it. There is a hidden agenda here, and the city manager made it clear that the constituents of Carol Keys, who's the elected official in my area, did not want me there, and that he wanted nothing to do with licensing me, even if I was entitled, even if it was appropriate. So he says, you know, that's why I wanted Frank here. You know, my job is at stake here, so I'm not going to look at it. What I would like you to do is I would like you to take it to another official and see if they can review it and license it.
My question is, why do we need Frank Wolin to be here?
Because
Not what happened in the past, but why is he a witness?
Because his testimony proves that the city manager refused to even review my paperwork. So if the city manager is the person who's authorized to license me, he decided to delegate his authority to another official, which in the city ordinances, it allows that. And I have the city code that it's in one of the letters that Frank responded to, that the city manager can delegate his authority on matters of licensing.
I saw that in the code, and the answer is yes. I agree with you.
Okay, so the reason Frank Wolin needed to be here is because I wanted him to be able to present and testify, so that way it's for the record, and to put things into the record in case the decision here is not favorable for me. And I in addition to having Frank as a witness, these are complex legal issues. Because he's a witness, he cannot be my attorney. I need time to find another attorney. The subject of the case in the circuit court we had talked about, and that I feel it's really appropriate for us to wait until the case is determined, or at least to give Frank the opportunity to come back and testify, so that way his testimony can be put into the record and, if needed, possibly be used in a different forum. The city's code enforcement action is an end run around the circuit court, so the case should be continued and the hearing staged till the circuit court decides.
Permission to respond, Judge?
Yes, go ahead.
So I'll address all of that. I'll try to do it in order, as Mr. Gilinski stated. The first thing, the circuit court case that's pending, the city's response to that is that at this point, it's a stall. It's been over a year, and there's not even an attorney on that case. And I've reviewed the docket, and there has been nothing going on in that case. The second statement, as in Mr. Gilinski needs time to find an attorney, the last time that we were before this court, Mr. Gilinski stated the same things. He knew that when Judge Kuzo changed a date for May 15th to be heard in front of Your Honor, that he needed an attorney, and I don't know what steps he's done to get that attorney, because there's no attorney here present with him today. So that, again, is a stall in order to pause this case. The third thing that he addressed, as Mr. Wolin is a key material witness, that also has to do with the circuit court case. That has nothing to do with the two cases that are set here today before Your Honor. That is also, again, another...
Yeah, Mr. Wolin was not present when these violations allegedly took place. He's not here to testify, or he wouldn't be here to testify. He would never testify as to whether or not there was a short-term rental violation, correct? He wasn't there.
No.
Correct.
When
He
the
has
citations, okay.
Correct, Judge. He has nothing to do with these two cases that are before Your Honor to decide. The last thing is, in terms of Mr. Gilinski's comments as a hidden agenda and mentioning the city manager, those are obviously all allegations. That is not, although our code does speak as to the city manager is able to make that determination, the city manager has not been subpoenaed in this case, has nothing to do with this case. In addition, the state regulations change, and there's a licensing portal specifically that I have, and I can show Your Honor, from June 3rd, 2016, where the assistant city attorney at the time looked up all of the homes in that area that were licensed by the state to have short-term rentals, and Mr. Gilinski's property was not one of those homes. So again, another reason to stall these two matters. It's a city's position that we need to go forward on the two cases that are for short-term rental and advertisement that are before Your Honor today. and all of the matters as it relates to the circuit court case need to be handled by Mr. Galinsky or an attorney of his choice and should not be heard in front of your honor.
Okay.
May I respond?
Yeah, sure.
Okay, the first thing is I'm having financial problems. I even filed bankruptcy not long ago. And my house was almost foreclosed on. So financial reasons have, attorneys are not cheap for this type of matter. And I need to find one both for here, and I need to, it might be the same one I use obviously for the other, for the state. So that's one. The second thing is, Mr. Dixon was fired after he licensed me, very, very quickly. So there is a hidden public agenda here. And Frank Wolin is the person to be able to
Yeah, but we're not
testify to that.
gonna get into that
Okay.
here, okay? We're not
Okay,
gonna get into that here. Anything else?
Regarding 2016, when I began doing the vacation rentals, I wasn't even aware that there was an ordinance with the city that prevented me. I don't even know when I first got my violation. All I know is when I got licensed by Mr. Dixon, all of my violations disappeared. I was licensed for 7 months. If I still had the license, the two cases right now would not be before you, Your Magistrate, because if I had my license like I'm entitled to, and there's nothing from Mr. Cazot or from anybody from the city that ever stated that my information did not meet criteria. I'm entitled. I was doing it before the law had changed. I have all of my evidence. Mr. Dixon reviewed it. He's the code enforcement administrator. He knows the law. He's a city official. He reviewed it and he licensed me. So the two cases that were here before you today, if my license remained, we wouldn't be here, because if I had a license to short-term rent, it stands to reason, it's logical that I can advertise in the Airbnb for vacation rentals. And I'm being cited for advertising, and I'm being cited for renting. Both of these cases would not be before you today if I had my license still. So how can she say that they're not related? I don't understand.
All
that.
right, let me cut to the chase, because I've been involved with drafting legislation on short-term rentals in 2 other cities, and I am very familiar with the process of licensing short-term rentals. But before I get to that issue, I want to state for the record that my powers as special magistrate are limited. They're limited by state law, Chapter 162. They are limited by the city code. And I cannot adjudicate your issues before the circuit court. And I'm going to be a little lengthy. We have a court reporter, and I want to make sure that everything is on the record so that everybody's rights are fully protected. Under the city code, the special magistrate shall be bound by the interpretations and decisions of the duly authorized city and county boards or appropriate jurisdiction concerning the provisions within their respective jurisdiction. And that's Code Section 21-33. And certainly state law is to the same effect. The city code also provides in Section 2-602, city attorney, the powers of the city attorney. The city attorney serves as the final authority with regard to legal issues involving interpretations, enforcement, and implementation of the LDRs, that's land development regulations. So,
I'm sorry, city attorney or
the
city manager?
City attorney,
Okay.
Section 2-602, city attorney. The city attorney serves as the final authority with regard to legal issues involving interpretation, enforcement, and an implementation of the LDRs. So, what happened here, and again, I want the record to be clear, and by the way, I have to accept that provision of the code, so whatever the city attorney has decided is the law with respect to whether or not you were grandfathered, that decision I cannot overrule. That can only be done by a circuit court judge. I have to follow that decision.
Understand.
Having said that, I have looked at the letter of Andrew Dixon dated November 19th, 2015, where he talks about RU zoning, RU residential estate district, okay? Under the RU zoning, that means residential uses. Hotel, motels, and lodgings are not permitted. It is a residential, single-family neighborhood district in the city which does not allow short-term rentals. I'll let you answer. I'm gonna be a while, so, hold your fire.
New to me.
I'll be happy to respond once I'm done. So, here's where the short-term rental issue is affected by the opinion of the city attorney and why he reversed the opinion of Mr. Dixon. Mr. Dixon keeps calling it a lawful use, a pre-existing lawful use, which he did not have the authority to so designate because it was not a lawful use. Why wasn't it a lawful use? Because under section 5-1610 of the city code, which deals with short-term rentals, it says it shall be unlawful for the owner of a single-family dwelling unit, including townhomes, located in a residential zoning district to rent or lease the dwelling to another person for a period of 3 months or less, or to lease or rent the subject dwelling more than 4 times in a 12-month period. And what's interesting is that when the city adopted this ordinance, it did not provide for any grandfathering. It could have. North Miami Beach did it.
I see it right here.
Wait a second.
Okay.
Because the ordinance does not provide for grandfathering of existing unconfirmed or existing non-conforming uses, because the ordinance doesn't allow for grandfathering, nobody, whether you were operating on it, operating the property as a short-term rental or not, you were not grandfathered by the city. Now, North Miami Beach did. Miami Beach did when they passed their short-term rental ordinances. They said that certain properties that had been already operating as seasonal rentals, short-term rentals that had been allowed to operate either by the state or by the city previously with a license, they could continue to operate. No such thing happened here. So therefore, bottom line is that whatever you were doing before was being done illegally, and the city, in adopting the ordinance 5-1610, did not grandfather you. They could have. And the planning director's letter, therefore, based on case law that I have reviewed, is called ultra virus, which means that he didn't have the authority to do that. And there are a couple of cases that I looked at. One of them is out of Naples, Neapolitan case. I have copies of them here. If you would like, I can provide you with copies of those decisions. So bottom line is that you are not grandfathered. There is no such thing as grandfathering short-term rentals because the law doesn't allow for it. And if the planning director or anyone else issued a letter saying that you were grandfathered, that you had a lawful use before, that is an error. That's ultra-virus. So I'm stuck with the final decision interpretation made by the city attorney, which said that you're not grandfathered. and that you have no right to operate short-term rentals or seasonal rentals at your property. Now, I could be dead wrong about these issues. Those are the issues that will hopefully one day be litigated. And if the court finds that you are indeed grandfathered, the city will have to recognize that. But based on everything that I've heard, your uses have been illegal from day one. And therefore, I don't see anything that Mr. Wolin can come and tell me, because these are purely matters of law, not factual. So anything he could say would not take away from anything I just told you.
Yep.
So now that I've basically laid out the law for you, tell me why I'm wrong.
I think you're misinterpreting it. The law and the regulations, I had Mr. Wolin way back review the ordinances from North Miami, and there was people that were grandfathered. Grandfathering was a possibility if you were. So what you're telling me that North Miami Beach can do it, Miami Beach can do it, but North Miami can't do it? Frank Wolin didn't review the ordinances in North Miami Beach. He reviewed the North Miami ordinances, and according to the ordinance he showed me, that I was able to be grandfathered in, and that all I had to do was prove and provide the evidence and to show that I was doing this before. There's even language in your North Miami ordinances that states that you have to be doing it. You can't stop for 180 days. You have to do it. You have to be continuing to do it. So there's language in there detailing specifics on how you can be licensed. So I don't know if you're reading something from the state of Florida versus the city of North Miami, but according to my research, the state of Florida came out with a law saying that you cannot stop homeowners from renting their house short term as of
2011.
As of 2011.
That's
But
right.
but if before 2011 the city adopted an ordinance preventing the homeowners from doing it, the city will supersede the state.
That's right.
Okay. See,
But you're
And I know
mixing,
the person who made that law, 'cause I talked to him.
you're mixing apples and oranges, okay? The city did have,
But that doesn't apply to me. I know that because
Okay.
because the state made that law after the city of North Miami made their law. So I'm bound to
Okay.
the city's
as
ordinances.
long as you comply with section 5-1610, that it can only happen for a period of 3 months.
No, that's
residents of-
anybody. Anybody
Yeah,
can rent their
yeah.
house out for more than 3
Yeah,
months.
yeah.
But to be grandfathered in to rent daily, you have to
Yeah.
be able to prove that you have been doing it before the ordinance was passed, and that you have been doing it consistently, which I did. So I don't know what you're reading from. I'm not a
No.
lawyer, and I would need an
I am-
attorney to
I am
to
reading
review
from
this.
the city code, section 51610,
Yeah, but you're not-
which provides the parameters of conducting short-term rentals in the city of North Miami. There is nothing in the code that allows for grandfathering anyone in the single-family residential neighborhood, period. What you're talking about, and you're trying to confuse one issue with another, is non-conforming uses. Yes, non-conforming uses will be lost if you do nothing with your property for a period of time. You lose your non-conforming. This was never conforming. This property that you're renting out on a daily basis in a single-family residential neighborhood, which is totally contrary to the single-family residential neighborhood regulations in the city code, this property was never grandfathered. Where does it say?
I don't understand.
Where?
Yeah.
What evidence do you have
What-
that this property was ever grandfathered?
What's the non-conforming versus renting? It's not the same thing? I don't understand what that means.
Non-conforming means that if you have been using a property lawfully,
Mm-hmm.
and the city changes the law, then your property will continue to operate
I s-
as a non-conforming
I
use.
started with HomeAway, and I was renting to people for vacations. There was never illegal activity at my house. If I have If I have people coming to my house and they're gonna rent my house for a birthday with 20 people,
That's a business use, that's a commercial use, that's not allowed in a single-family district. That's like
that
operate.
wasn't, if somebody comes and says they wanna rent my house and they're staying there and they're having a birthday party with 20 people, that's an illegal use of the house?
That's not what you're using the property for. You're not conducting birthday parties or
I'm
anything
renting my
else.
house out. It's my right to rent my house.
Subject to the regulations of a
In
single-family
2000
residential
From
neighborhood.
2002 to 2008, there were no regulations preventing anyone from renting their house out daily or weekly. And I was doing that before the regulation changed. So now I'm trying to make my case that I'm doing exactly what I was doing when there was no ordinances from the city of North Miami, and I've proved it.
The city, and we're going to shortly come to the end here because we're in areas that are not that are not relevant to today's hearing, but I just want you to understand why Mr. Wolin's testimony would be of no value to you, because I've concluded as a matter of law that you have never been a lawful short-term rental property.
How can you make that decision? Were you here in
Because-
2008 when I
No,
was renting my house out?
but I have the city's zoning regulations which prohibit the activity that you have been conducting because they're not allowed in an R1 district. And when the city could have grandfathered you in 2009, the city chose not to. There is no grandfathering for short-term rentals that pre-existed the enacting of the ordinance.
So then how does a homeowner or a property become grandfathered in then? It seems like there's no way for that to happen in North Miami.
Only if the city allows it, and the city never allowed it.
I never requested the city because I didn't know that there was a law.
There had to be the ordinance that was passed. If the city commission had wanted to grandfather properties and allowed you to do daily rentals, they would have put that into the ordinance as other cities have done. This city did not do that. And the planning director doesn't have the authority to overrule the city commission or the city attorney.
That's not what the city manager told my attorney. That's not what the attorney told me. What I was told that there is a way to be grandfathered and it's in the regulations.
I am telling you that there is, the only way you can get grandfathered in to do what you're doing is to ask the city commission to allow you to do it. That has not been done. So,
Who's the city commission?
the people who sit up here
Uh-huh.
are the only ones that can grandfather you in. Not the planning director, not the city manager.
Not the city manager.
Not the city manager. Those are legal issues. And for them to grandfather you means that they exceeded their authority in doing so. They committed an ultra-virus act, which they're not allowed to do. Only the city commission can do that. Bottom line, I have to abide by my powers are only those that are delegated to me. The code says the decision of the city attorney is the final authority on the interpretation of the land development regulations. City attorney has ruled that you're not grandfathered, and that therefore the only issue before me today is whether or not the code was violated, and that is my decision.
Well, I would like to know if I will be granted a continuance for the other reasons that I have requested.
No, continuance is, this has been dragging along for years now, and you've had an opportunity to get an attorney.
And to respond to her comment about the state case, nothing going on. I've had my attorney available for over, he was just, I just asked him.
And again, we're
because I couldn't
sidetracking
keep
here.
paying him.
We're
And
sidetracking
look,
from the original cause.
There was never any initiative from the city of North Miami to even entertain that, because I believe that they had felt that they were in error. Otherwise, why wasn't the city actively trying to do that case?
Look, you filed a lawsuit. It's your case. You have the obligation to.
I thought we did. I thought I
You-
filed my reasons.
Well, there is no reason why a deck action filed in 2016 is still pending. Because deck actions, as a matter of law, get priority over any other case. And so the
The
fact
city-
that somebody has been dragging his or her feet on
The old-
that case,
The old city manager or the old city attorney.
whatever, that is not before me. That case should have been finished by now. It should have been finished a year after it was filed. And here we are with an open case that has not been properly prosecuted. So I'm going to let the city present evidence on the violations that are alleged regarding this property.
Okay. Would you rather start with the advertising or the rental? So it's either 03 or 04.
Let's do the advertisement first.
The advertisement first. Okay. City of North Miami Code Enforcement Officer Perez. Today we're hearing the case in reference to the property at 2100 Northeast 121 Road. The violation is in regards to short-term advertising, which is prohibited per the code. The code does not allow for any advertisement at all to be online or posted or anywhere for the matter for short-term rentals. I received as a complaint several documents for the short-term advertising that I have listings. The property owner himself has actually even given testimony saying that he does have the listings up and the advertisement up. So really, at the end of the day, the city is requesting the maximum repeat offender fine daily to occur until all the advertisements taken down from any source whatsoever.
Do you have copies of the advertisement?
Yes, I do, and
May I see that?
the city attorney also has copies.
So many, which one?
Yeah,
As of January, they were all removed. There's no
that is not the
advertising.
case. We have
Yes.
photographs showing most recent ones as well.
Then it's people putting
And-
my house on Airbnb without my permission, which has happened many times.
Judges-
But my listings
let
are
me-
gone.
Okay, I will let you respond to what the code officer is presenting, but let me hear from him first, and then you can
Sure. Yes.
rebut.
Yes.
Just, I'm gonna be passing up several things. The first one is. the
Tell me
com-
what I'm seeing.
Yes, the first one is a complaint with, that Mr. Perez was referring to with the attached photograph, from a nearby resident. The second one is an advertisement that was searched by one of the code enforcement officers with Mr. Galinsky's property. I'll also pass up Mr. Galinsky's advertisement where his photo is even on the advertisement.
What's the date? What's the date of that?
You can look at that as well.
Let me check.
I believe I circled it for.
Uh,
And most recently, Judge, there was an incident report on May 9th, 2019, the last time this case was.
all right, but that's the next case. We're talking about
in terms
the
of the rentals.
No. We're talking about advertisements only first.
Okay.
There are two
Right.
cases.
I'll
This
wait.
is about advertising.
Okay, I'll wait for that one.
Okay.
Which only confirms, to be honest, the advertisement being legit. Because if the advertisement was not legit, then there wouldn't be a rental in the first place.
Right.
Right.
I think I have more. 1 second.
Just because it's difficult for me to see it, but tell me what dates these advertisements were made and in what platform?
Sure. So this, the complaint originally, the date says March 16, 2019. That was from the neighbor, and she listed the rentals when she looked it up on booking.com. The second one was done as a search by one of the code enforcement officers, Karen Jean Louis, and she put it in for Friday, April 26, 2019, checkout date Wednesday, May 1st, 2019, and that's the black and white photos that the city passed up to your honor to see if she can make a reservation, and she could make a reservation. So that's the second advertisement. Let's see here. We have one from March 16 at 11:34 a.m., and that's the one that depicts Mr. Galinsky's home with his photo on it. And there's actually a review from, let's see, who is it from? From Shirley, which says that they found the property on Airbnb, that their family, 11 adults and a baby, enjoyed their weekend there at the mansion. What a gorgeous view. Let's see what else we have. This one's from
2018.
2018. But those are the ones that, Your Honor, got to.
All right, and I'm looking at section 5-30 of the city code, which is titled prohibited advertisements. Any advertisement that promotes the occupancy of or use of the residential property for the purpose of holding commercial parties, events, assemblies, gatherings, or the rental of a single-family residential property for a period of less than 3 months, as prohibited by 51610 of the City Land Development Regulation, is prohibited and shall be a violation of this charter,
And Judge, I
of
apologize.
this chapter.
I apologize. There's one additional that is somewhat related to, well, it is related to the second one, but it also depicts the phone from one of the parties that was staying at Mr. Galinsky's home. It's an email from Airbnb, pack your bags, ready to go, March 21st, 2019, which the advertisement from Airbnb clearly had to be up for them to rent this
That
property.
is not my listing.
Which one is not your listing?
Those listings from Airbnb are people who have decided to illegally take pictures of my home, advertise my home.
And how do they
And-
gain
How do they
access of the
gain?
property?
How would they get
I,
access to
I,
the
I had
property?
somebody, I had this guy named Johnny come and he says, hey, I have a lot of houses and I'd like to manage your home. I says, I'm
That
not
is your
interested.
responsibility.
I'm not interested in
Yeah,
you
one-
managing.
one at a
Or
time.
they could steal the pictures off of the internet. All you have
Okay,
to do.
I
so-
understand.
So I
I
have
understand.
called Airbnb 3 or 4 times,
Okay.
and I've had people say they're being frauded. I've had other people tell me, "Oh, I got a booking for you," and I'm like, I'm not contesting that I'm not renting the house, but I'm not advertising it anymore on Airbnb
Anymore.
or on.
Have you ever advertised?
Yes, I have.
Yes, okay.
Yes. But
All right.
but what I'm trying to tell you is, as of February, my listing with Airbnb under my name, David Gotlinski, was canceled. You could go right now on Booking.com, on HomeAway. I have no advertisement on any vacation rental company right now. None.
When did you stop advertising short-term rentals?
February 1 is when Airbnb, I took it off
Okay,
of Airbnb.
and-
Judge, I
Yes.
just checked myself this past month, and I could go on there and see it, and so did the code enforcement
What was
officer.
it?
That is
Airbnb?
not my listing. I do not own that listing. That is not under my name. That's somebody
Objection.
took my
Okay.
home.
The code ordinance states there's no listing, period. It doesn't say that the owner can't put the listing. You just
All right,
can't have the
you
listing
know,
at all.
I understand.
But I can't
understand.
control what
Yeah,
other people do. It's like someone
understand that.
coming to my house and they have up 300 people there. I call the police on my own clients because that's not what they said they were going to do.
If, look, I've heard this a million times before. I understand that there could theoretically be some guy who hates your guts, who is your mortal enemy, that wants to make trouble for you and will post 15 postings
or-
for your property.
Or
I
want- or
understand
wants
that's
to
a
get
possibility.
bookings from my house without my permission.
Or there may be
And make money.
brokers, there
Yeah.
may be brokers who know that you're in the business and they may want to bring clients to you.
Correct.
All of that is
Correct.
true, but I think that what I'm hearing is that you've been advertising. If you thought that you could do it legally, why not advertise it,
Of course.
right?
Of course.
So the issue
I
is,
was
you know,
licensed for 7 months.
so he's been
with no
advertising.
appeal
You've
by
been
the city.
advertising. You've been advertising short-term rentals, whether for a day, a month, a year, 10 years, whatever, and that's what we hear about. And we have some photographs that even have your picture on it.
Yeah, but they're trying to say that I'm continuing to do it, and I'm not. I just wanted to let
Okay.
you know that it's
Judge-
been, that
I
it's been
understand.
stopped.
He absolutely is. There's an incident report from May 9th that was written by one of the officers that literally states, I made contact with Mr. Spence, who advised that he rented the residence for 2 days from Mr. David Galinsky for $2,500. That was right after we were last here.
We're not
hearing
here
this
about
case.
renting. We're about
We're
this
here
case
about
about
both.
Yeah.
advertising.
But how else would he have gotten into this home? He's clearly advertising. We've seen all of the advertisements everywhere. He's admitted to advertising. It's the city's
Yeah,
position.
I have clients now by word of mouth that call me. I don't need to advertise nothing.
Okay.
I've been doing this since 2008. This is already 11 years.
Yeah, you
I
thought
built up
you thought it was
clientele.
legal, so
Yes.
you evidently you
The
felt that
city-
this was
your
one way
city
to get
told me
business.
it was legal.
Right. So based on whatever you were told,
It's not a
whoever
fact.
told you, you went ahead and you started doing your advertisements in all these various platforms, which you thought was legal, but it wasn't legal.
And I hired an attorney, and my attorney, who was the mayor of North Miami, came, got the ordinances, and told me the exact opposite of what you just told me. He told me that North Miami Beach,
Relevance.
Miami Beach have a grandfathering clause.
Yeah, that's not what we're here for today.
Yeah. Okay. So
Well, he
what do
brought
we?
it up, so I'm just.
Yeah, I'm
You're trying to say
very
that I've
familiar
been-
with the issue, and the fact that was mayor is very impressive. I happen to know him. I think he's a nice guy, but whatever advice he may have given you, I disagree with it.
Well, maybe the state court will
Yeah.
disagree with you.
Yeah. But again, I'm not weighing on those issues because I'm bound by what the city attorney ruled, which is you're not grandfathered and you can be cited and you don't have the right to do what you're doing. So what do we do with the admitted violations of the code insofar as illegal advertising is concerned? What
My
is your
recommendation would be the maximum for daily fines of a repeat offender of $5,000 per day until all the listing advertisements are removed.
Well,
They're gone.
he can't force someone to
He
remove.
could
he can't-
email or have contact with the booking companies and have them take them down permanently,
Okay.
which other clients
Not-
have done.
Not true. I have called Airbnb. There's a guy named Johnny. He's from Kansas City. He got 30 homes. He put my house up as Poseidon's Cove. So I'm like, and this is when I had my listing up with Airbnb last year. And I got people calling me going, there's someone out there with your house with a different name, named Johnny. And I'm like, I called Johnny up. I go, what the hell are you doing? I told you I didn't want to have you as a management company. Remove it. I called Airbnb. They removed it. 2 months later, it's back.
He just admitted to calling Airbnb and having them remove it. He
Yeah.
can't do it.
Can you call Airbnb
I
and
did
say?
have them remove it, and it came back.
Then call again.
Can
have
you
something written.
look? Let's not go back and forth.
Call again. I mean,
There is a way that you can contact Airbnb and request that your property not be put on their platform. They do it all the time. It's one of the newer.
do you know what the other people are doing? They're putting 2101 Northeast 121 Road. So Airbnb is not catching it because it's a different address.
If it's a different address, you're not going to be
pictures.
cited.
But, Judge, in my
No,
argument...
they're not. Well, you're
Excuse
citing me
Mr.
then for it
Galinsky,
because
am I-
the one she's
am I-
talking about is a different address.
And my argument is when these, because I've seen them myself for this property specifically, when they put in a different address, if we're going to go with Mr. Galinsky's theory, who is there to meet these people to provide them with a key to access the home? If it's clearly not Mr. Galinsky putting them in there
I'm
himself,
not
Yeah.
contending that I'm
it
not
makes
renting
no
my
sense.
house.
There's no
Yeah.
logic
I
as
don't
to
know
him
where
not
they're- I don't know.
advertising
Yeah.
The people
his
sending me the
property.
clients aren't saying they're coming from Airbnb's
Yeah.
advertising. They're saying I have a client.
Yeah. So the issue now
You're
is
here arguing me
is-
renting my house. We're here. This case is about advertising.
Right. So what is the city's recommendation insofar as advertising? And I don't want to suggest that that if somebody is trying to hurt him financially or otherwise,
Or
and
trying
decides
to, or
that
trying
they
to
don't
benefit
interrupt me.
financially
No,
themselves. Yeah.
don't interrupt me.
I'm sorry.
If somebody maliciously places an advertisement in the front page of the Miami Herald advertising his property and it's not him, there's no way that I'm going to find him guilty of that.
I understand.
There's
but There's
no
also
evidence of that before
Okay,
Your
I
Honor.
just want that to be clear. If he has no control over somebody that places an ad in whatever platform or newspaper, if he has no control, I can't hold him liable for that.
Judge,
so how do we deal with that?
Correct. I personally showed up to Your Honor, and I can pass it up again. One of the sites that he advertised on, people stayed there. So he's advertising, they stayed. There's logic to that. him not advertising and someone named Johnny profiting from this big scheme to hurt Mr. Galinsky and them not being able to stay, that's not what's before Your
Okay.
Honor. There's no
I am
facts or evidence.
I am convinced that there has been illegal advertisement.
Okay.
Okay.
Craigslist also. I've
Okay.
never advertised on Craigslist,
I am
and I got all of a
convinced-
sudden I
I
got
am
people calling me.
convinced-
I'm like, I never put my
I am
house.
convinced that there has been a violation of the code as far as illegal advertising short-term rentals.
We're asking for
Now,
the max.
what is it that you are, your code provides for a $500 penalty and 1,000 if it's a repeat violation. I am not going to go to 5,000 because under Florida statute 162, I cannot cite somebody unless it's a life safety issue. I cannot fine somebody $5,000. So what you're telling me this is a repeat violation. He's been cited before. Has he paid a fine before?
He's been found guilty previously.
Okay.
And Judge, I can also pass.
I've
pass
never
up to
paid a
you.
penalty. When I was licensed by Mr. Dixon, all my prior code violations were gone, were removed.
He's had 16 rentals, 3 advertisements. This has been going on forever. In addition
the
to
advertisements.
3 advertisements, 16 rentals. I can pass it up with the case numbers and the violations, in addition to the aftermath of
He's
when
been
these
found
people.
guilty of some
Where?
of these violations?
I don't see, no.
In addition to illegal things going on this property.
We're gonna get to all of that, but we gotta take first the issue of advertising. So, has he been found guilty previously of illegal advertising? That's my question.
Yes.
No, not that I know
Well, I
of.
wanna
Oh,
see.
all right.
That's why I'm asking.
Okay, show me, where?
That's
Where have I been found guilty? I've been charged, but it's never been decided. Because I was licensed, and when I was
Give us a second,
licensed, they
Judge.
all
There's
went
so
away.
many, we need to get
Okay,
which one is.
let me just conduct this in an orderly fashion.
The rental.
I don't know if it would please the court and the city attorney to know that my house is up for sale, and hopefully I will have it sold soon.
All we're asking is that the illegal rentals stop. That's all.
And the illegal things that are happening on that property.
Right.
If you rent your house to someone and somebody kills somebody in the house, you're not your fault. If somebody does something in the house that's out of your control, it's not your fault.
Mr.
I
Gus-
have people
Yeah.
coming to rent my house, and they say, we're just coming for a regular rental. And then all of a sudden, they turn it into a profitable thing. As soon as
Well-
I see that there's anything going on there that is misrepresented, it says in my own rental contract that if you perform any commercial activity, if you do anything that turns the house into a nightclub or sells alcohol, it's not only against the rules, it's illegal. And if I find out, I will actually call the cops on my own tenants to
Mis-
get them out. And I've
Mr.
done that
Galinsky,
before.
Did you not have your own criminal case in matter regarding this property? Were
That-
you
that-
the
that-
defendant
that-
in the
that-
case?
That has nothing to do with what we're talking about.
Absolutely, it does, because if you're referring to other people who are renting your property, who are creating illegal acts in your property,
Mm-hmm.
there is, and I have the evidence, a criminal court case, which you're currently
I-
on probation for,
I-
correct?
I-
Regarding
yes,
your property?
not regarding my property.
No, it
no.
didn't happen on your property on
Yes, it
2100
happened on my
Northeast
property, but it has
121st
nothing
Street?
to do with what we're talking about here today.
I can pass it up
Okay.
to the court for your
Yeah.
honor to
No,
review.
no, I don't need to get into that, but
You are under
And,
oath, sir.
and you're crossing the line.
And you're under
You're
oath.
crossing the
And
line.
you're under
Stop.
oath.
And you're being,
Yeah, but-
disrespectful.
No,
That
you're
we-
under
We're here
oath.
on a civil matter,
And
okay?
you need to be truthful
Okay.
regarding what you're
Yeah,
saying.
yeah,
You're
and we
under
need to
oath.
all
stay
right,
on
guys.
topic.
All right, guys, cut it out.
And stop rolling your
Yeah.
eyes at me.
Sir,
I'm going to have to ask the officer to maintain control because that's not permissible.
Well, she's individually attacking me.
don't-
This has
don't-
nothing to do with that.
Okay.
no, I'm contesting
we
what
feel,
he's saying,
you know, both
lying
sides,
under oath.
both sides are very passionate. I'm trying to keep this civil. I'm trying to keep this just based on facts. And so,
That one has a fine. Yeah.
let me ask the city attorney. I have a, I see that your code allows a fine up to $5,000 per day for repeat violations, but my understanding under Chapter 162 is that there's a cap of $1,000. What is the basis for, in your code, going higher than what the state mandates?
Judge, we can go over what the state mandates. 162 is a guide for us to do our ordinances, but we can go up to the $5,000.
I'm looking at 162
What?
162.09.
162.09. 1 second, Judge.
Look at 2A and B. This is one of the issues that is being litigated right now by Airbnb, is the fine amount.
Yes, I'll refer Your Honor to 2D. A county or a municipality having a population equal to or greater than 50,000 may adopt by a vote of at least a majority plus one of the entire governing body of the county or municipality an ordinance that gives code enforcement boards or special magistrates or both authority to impose fines in excess of the limits set forth in paragraph A. Such fine shall not exceed 1,000 per day per violation for a first violation, 5,000 per day per violation for a repeat violation, and up to 15, excuse
it.
me.
Got it.
And just to let Your Honor know,
Got
they increased because we have over 60,000 people in terms of population in the city.
Yeah, I see that. I know there's a pending challenge by Airbnb against the city of Miami Beach because the city was imposing $20,000 fines per violation. So that issue is currently in circuit court. So getting back to the issue at hand, has he been previously adjudicated guilty?
Yes.
Oh, did you give it back to me? Okay. That was in CESTA 2017000002, short-term advertising, 2100 Northeast 121st Road. Fine lien case, short-term advertising removed from websites. And I can pass that up if
Yes,
Your Honor
let me
would
see
like
it.
to
Is this by way of a ticket that is issued, and then if it's not challenged, then
If I'm
it's
not
imposed?
mistaken, that's actually a case that came in front of a magistrate. If it's a CE case, then it was in front of a magistrate.
Okay, but it could be a ticket if the city chose to issue a ticket, it would be done that way, or?
The city has the opportunity to issue a ticket if they choose so, but that one specifically came before a magistrate.
Okay, so I see one here, code ticket. The one that ends in 8. There's another one.
May I? Yeah.
Wait,
My-
I'm
okay.
trying to find out
Okay.
what the process is.
Okay.
Yeah.
So you can issue a ticket, the one that was adjudicated came before the special magistrate, and which one was that?
The one in 2017 by Officer Edmund Fitzel, it's the one that has the arrow to it. That one
Okay.
has a fine lien on it. It was a fine lien case.
Okay,
Sorry.
yeah, okay. Same property?
Correct.
Okay,
Same owner.
okay. All right. Yes, you wanted to say something?
Yes, ever since Frank Woolen represented me for code violations, I am unaware that there has been any hearings other than the ones that have been today. All of the other hearings have been continued or have been postponed or have been canceled due to licensing. So the hearing that they're claiming where I was found guilty, I have no knowledge of that. And was there anybody at the hearing for the plaintiff, for my side?
You don't need to
Apparently,
be at
there's
the
a
hearing.
lien on the property, right?
It's a finding case. I'm not sure if they have a lien on the property, but he doesn't need to be present for there to be an adjudication.
But don't I need to be notified if there's a hearing?
Well,
coming up?
if you were not notified and nobody served you, I suppose you could move to set it aside, but I have to assume if it's being presented to me as an adjudication, that it was lawfully done, unless you can come and show me otherwise.
Well, Frank Woolen would be the person that I would go to for that because he had informed me every time that every time that I got a notice, it was either put on my door, it was brought to the house, so I believe I got every notice. I know that there was a problem with an address that I need to change. It's an old address that I used to have in Hollywood. Apparently, the city of North Miami has that address, but Frank Woland, being familiar with the city of North Miami and having contacts and having representing me, has, from what I understand, has gotten all the prior hearings to be continued or to be canceled based on the licensing. So I
Right.
know of no hearings other than the one that I went to last
I can
2
only
weeks ago.
rely
All right.
on city records.
So what date was there a hearing
what is
that
the
I didn't
date?
go
What
to?
i-
Or
Judge,
there was no hearing.
I don't have the records
There
from
was no
his
hearing.
last.
No, but what is the date of
Adjudication.
what is the date of that
That was a ticket.
the ticket? It wasn't a ticket, it was an adjudication.
The only date that I have on here, and I don't know what it's actually for, is for 4/10/2017. If he wants to take that up with Mr. Woolen and look into that,
Yeah.
he can. At the end of the day, it's down as an adjudication for us, and it suffices as a repeat offender. So,
Okay,
That I have, I'm in objection to that because I know of no hearing date. They're not giving me a hearing date. They're just saying it's been adjudicated. I'd like to know the date of the hearing and which magistrate ruled on that.
all right, you can find out with the code
Mm.
folks. Let me get clarification from the fine schedule that I saw for short-term rentals. Wait, I'm asking a question. The fine schedule says 500. Is that the fine set forth in the city code for first violation?
1 second.
As a short-term rental, for a ticket, it'd be that.
Either.
For an advertisement,
I don't think the
Yeah,
code,
we're looking.
I don't think the code distinguishes one from the other.
and you're asking for the ticket amount?
What is the fine schedule for advertising, illegal advertising of short-term rentals? What does the city code say the fine is?
Well, I have it.
For repeat offenders is up to
No,
5,000.
the first offense.
1 second, let me look it up, Judge. The first is 1,000, Judge.
Okay. Is that for advertising or is that
Yes.
for illegal?
We're talking about
rental.
advertisement.
Can you show that to me?
Yes, 1 second, up to 1,000. My phone is slow, so.
Does it have a number like 5-30? What number is it?
Yes, I'm gonna give it to you. It's chapter 21. Chapter 21, 2120, subsection A. I can pass it up.
Yep.
So it's up to 1,000.
Fine and post.